It's the video you guys have been asking us for. The USCCA has updated the terms of their contract. We have read every single word of it, and we have a lot of thoughts on it. Stay tuned. This is attorney Andy Marcantel and attorney Mark J. Victor. We're the partners at the Attorneys for Freedom Law Firm here today to talk about USCCA's updated policy. How you doing today, Mark?
I am fantastic, Andy. People really like these videos when we do these really just reviews of other companies, and there's really no magic here. All we really do is go through and read the contract and cite to the contract and tell people here's what it says. And like all the other companies, there are good things about what USCCA is up to and things maybe not so good. And we're going to do our best to cover all of it today in as fair and an unbiased way. I think it's important that people know what we're about, right? Because here we are critiquing another company. And our goal is to do it as fairly, transparently, and accurately to really honor their company and our company. Our goal, and I've said it many times, is to get accurate information out to the market. There are things that are better about other companies than AOR. There are things that are better about AOR. And so really the goal of this video is to go through the updates that USCCA has made to their contract and cheer them on for the good stuff and point out things that we don't think are so great and then let people decide for themselves.
Absolutely. And we're going to point out the things we do like and we're going to point out the things we don't like. And the whole point of this video is to encourage people to do their own research, read the contracts. As you said at the beginning, there's no magic to this. Right. Spoiler alert, all we're going to be doing is reading the contract and pointing out our interpretation of it and what our feelings are of each clause. But on that note, this is going to be a big video, okay? And so I want to mention at the beginning, we're going to break it down into different chapters. And I encourage people who maybe don't have time to watch the whole video or who care about specific parts of the contract, maybe there's parts of interest to you. For a lot of our clients, for example, we've found that there's certain things about these contracts that they're more interested in. And that could be the deciding factor on whether they go with one company or another. So I encourage people to look at our chapter selection list in the description of the video. If it's something that catches your eye, if it's something you care about more, you can skip around in the video. But Mark and I are just going to go through every single aspect in excruciating detail.
Yeah, and something else to consider, if you're somebody who's thinking about, maybe I'll sign up with a USCCA or maybe another company, maybe AOR or some other company, it probably is worth your investment of time to get it right. To find out exactly what the offerings are, figure out what you want and what's a good fit for you. And this video is going to be our best attempt to sort of lay out what USCCA is offering. If we got something wrong or there's something we don't understand or something's unclear, then we stand ready to be corrected. And so we'll point out those things that we read. We say, I don't really know what that means or how that would be interpreted. And people will decide for themselves. We really are going to make our best attempt here to be fair to everybody, including USCCA, as we go through this review. So, let's get into it.
Yeah, absolutely. And as our viewers who are watching this on YouTube can see, the table right now is littered with documents. We reviewed a lot in preparing this video. But I think to kind of start with the story here, to kind of tell what happened, there was a email that was sent around on June 5th, 2024 from the USCCA, and it was entitled, "Your USCCA Member Benefits Just Got Better." And in that email, they detail some changes that they have made and updates that they have made to their policy and try to kind of give a brief summary of each one. And then there's also a link that you can click called Learn More, which kind of compares on their website the previous coverages to the changes.
Yeah, I think it's fair to say what we've reviewed here in coming to our conclusions, our best estimates about what the USCCA is offering. We've reviewed Tim Schmidt's email, the one you just talked about. We've reviewed USCCA's website itself to see what's there. We've also looked at the USCCA's membership agreement. That's different than the insurance policy offered by a completely different company called Universal Fire and Casualty Insurance Company. So those are all of the things that we've reviewed. But I think it's important to really understand, as you look at each one of these things, it's really all about the insurance contract, isn't
Yeah,
it?
there was a reoccurring theme with most of these documents that you just named out, Mark, specifically the email from Tim Schmidt, the USCCA's website, the USCCA's membership agreement. We started noticing a common disclaimer at the bottom of each of these documents.
Yeah, if you start with the email from Tim, I mean, there's all kinds of assertions in this email about the new updated program, and all that's great. But if you look carefully down at the bottom of that email, there's 2 stars there, and maybe we'll pull it up on the screen as I read it. Here's what it says, quote, "Insurance has been purchased by the USCCA and is one of the benefits of membership in the USCCA. Coverage and benefits are subject to the terms, conditions, and exclusions of the insurance policy issued to the USCCA by Universal Fire and Casualty Insurance Company, an insurance company with its principal place of business in Hudsonville, Michigan. Every USCCA member is an additional insured on the policy. Information provided herein is for informational purposes and is not intended to be a representation of coverage that may exist in any particular situation." So I understand this to very clearly say, look, don't go by what's represented in the email sent out by Tim Schmidt. You got to refer back to the policy. So in that email, you'll find there's a hyperlink. It says learn more. If you click that, it'll bring you to the website that details Delta Defense. And again, you see the very, very similar language on the website under Section 1. Here's what it says. Quote, "Coverage and benefits are subject to the terms, conditions, and exclusions of the insurance policy. Information provided herein is for informational purposes and is not intended to be a representation of coverage that may exist in a particular situation." Okay, well, you might have thought that the things that were in Tim Schmidt's email and the things that are on the website are actually intended to represent what the coverage is, but that's not what the small print says. The small print says, take a look at the insurance policy.
And then, not surprisingly, when you get the USCCA membership agreement, you look at it, you will see a very similar disclaimer under the section entitled Insurance Disclaimer. It says, quote, "All coverages are subject to the terms, conditions, and exclusions of the actual policy." Click here to view the policy. Informational statements on USCCA's or Delta's website regarding the policy, insurance coverage, and other content are for general description and informational purposes only, do not constitute professional advice, and neither the USCCA nor Delta provides any warranty as to their accuracy. Okay, what does this mean to me? This means that everything is pointing us to the actual policy.
I mean, we're not going to even stand behind what we've said, right? We're not going to say anything about the accuracy of the stuff that's on our website, in our email, in our membership agreement. It all goes back to the policy. So I think it's pretty clear. If you want to understand what USCCA is offering, don't look to the email. Don't look to what's on the website. Don't look to what's in the membership agreement. Look to what's in that policy. That controls everything.
Self-defense liability coverage declarations, Universal Fire and Casualty Insurance Company. That's the document you need to take a look at if you want to know what the actual policy is.
Okay, so we've gone through every word of this, and let's start by saying there are some really good things that USCCA has done here that I like a lot, that I want to give them credit for. First off, they've added red flag coverage. I think this is really important, right? Because we in the gun community know that these red flag laws have gotten completely out of control. For people who don't know what this is about, imagine boyfriend, girlfriend get into some kind of an argument and girlfriend runs down to the courthouse, which is usually a low-level court with maybe a judge, not a lot of experience. In fact, some courts have judges in these types of courts who aren't even lawyers, and they essentially swear out a statement that say, look, boyfriend threatened me, and he's got a gun, and I want you to take his firearm away. Judge essentially issues a restraining order, clicks a box that says all guns got to be surrendered, and boom, there go your Second Amendment rights.
Yeah, one of the biggest problems with these types of hearings is they're what's called ex parte hearings, and all that means is that only one of the parties is present for it. In other words, the person whom the court is making the decision on whether to take their guns doesn't even get to be present to tell their side of the story. We might just be dealing with an unreasonable plaintiff here. And so what a red flag law is basically saying the court is authorized in an emergency situation to take the guns first and give due process second.
Yeah, there's a lot of problems with these hearings, so I definitely want to commend the USCCA for adding this coverage. This is really important coverage, and it's capped at $15,000. Frankly, I think that's a reasonable cap.
That sounds about
here.
right.
Yeah, we've done many of these hearings, frankly, at our law firm, and we've had results that have included getting the entire restraining order quashed, and also results where the restraining order stays in place, but the provision that denies the person the firearm has been removed. So, and it's never been more than $15,000. So in fairness, I think USCCA did a really good job here, and a good thing adding the red flag coverage. I got no qualms with them capping this at $15,000 either.
Sure. Another thing that I like about their updates is they're increasing their bond amount.
Yeah.
I think that's a good thing. We've talked extensively about bonds and how bonds are set and everything like that. And this is an important part of the process, and it's an important thing to be presumed innocent. And in many ways, many of these high bonds that are set rub up against, in our view, the presumption of innocence in this country. And so anything that USCCA is doing to increase the likelihood that their members aren't going to have to sit in custody while they're presumed innocent, I'm in favor of.
Yeah, this is definitely a positive change. They've upped it to $250,000. That's pretty significant. What this means is if you get a cash-only bond up to $250,000, they're going to post the $250,000. That's how I read it. If it's a secure bond, then up to $2,500,000. Usually the bondsman wants 10%. That's your $250,000, but you got to have collateral. And so if you don't have collateral up to $2,500,000, this probably isn't going to help you that much unless you get a cash-only bond. But nonetheless, this is, I think, kudos to the USCCA for doing this. This is a good update and an improvement on their part.
Absolutely. I also like the fact that they are giving options for expungement and sealing of records where available by law. So there's a huge, that where available by law is kind of a huge proviso here. And that's me putting my own language in because as somebody who practices around the country, I know that different jurisdictions feel very differently about expunging records. There are many jurisdictions, for example, that don't allow you to expunge or seal your records. But I like the fact that the USCCA added something in that said, if we are able to do it in your state, then we'll be able to do it for you.
Yeah, and this is capped at $5,000. I think that's also reasonable. I point out there's some very strict timelines here that apply. And, you know, you might not know, say there's a law enforcement inquiry, maybe there was even an arrest, and then charges aren't brought. They don't usually send you something that says, hey, here's your notice. We've decided not to bring charges. And if you let those time limits go by, then it looks like you might not be able to access that $5,000. But nonetheless, let's give USCCA some credit here. This is a good ad. It's a $5,000 option to either expunge or seal a record if this is applicable in your state, and it may or may not be, but I think we need to give credit where credit's due here.
Absolutely. And then loss of earnings coverage. So presumably if you have to go to court, if you have to go and defend yourself in one of these types of incidents legally, and you miss work or you miss earnings or something like that, it sounds like USCCA is adding to their coverage. They're going to compensate you up to $10,000. I think that's a good thing.
Yeah, I think that's a very good thing. People who are living paycheck to paycheck, you get arrested, you're in custody for a while, you lost up to $10,000 here. USCCA is going to reimburse you. We got to give them credit for that. I think that's a very good add to their program.
Yeah. So those are all the things that we like that they changed.
Yep.
And we wanted to definitely give credit where credit's due. There are many parts of these changes, though, that we're not so excited about, Mark.
Frankly, there's some problems here. And much of this is not our opinion. This is just, we're going to cite to the contract. I know people have said in past videos, oh, you guys are just interested in tearing other companies down and you're being unfair and this and that. That is not our goal. Our goal is to cite to the contract. So let's get to it. Let's just set the stage with a few things. First off, let's talk about the specific membership agreement with the USCCA. Maybe we'll pull it up on the screen. And I'm looking at a section that is entitled Member Termination. Here's what it says. The USCCA has the right to terminate the membership of any primary member or secondary member at any time if the USCCA determines in its sole and absolute discretion that such primary member or secondary member's actions or behavior is contrary to the interests of the USCCA.
What does that mean?
I don't know, contrary to the interests of the USCCA, but then continuing, and thereafter, all of the rights of the primary member and or secondary member shall cease. Such termination may be retroactive in the case of fraud, bad faith, or criminal or malicious action or intent. Any such decisions regarding termination shall be at the sole and absolute discretion of the USCCA. In the event of termination, Delta will refund the terminated primary members or secondary members, if applicable, payments pursuant to the USCCA's bulletproof guarantee, end quote. Okay, so not only can they terminate you for any reason, really, anything that's contrary to the interest of USCCA, but they can make it retroactive. I don't know about this language. It can be retroactive in the case of fraud, bad faith, but what about criminal intent? What if you commit a crime? Does this allow the USCCA to terminate, not just terminate the member, but to make it retroactive before the criminal intent arose, which means, sorry, you did something last week that you're reporting now. We've terminated you as of 30 days ago, but don't worry, we'll refund the money that you paid in that time since termination to now. I don't know exactly what that means or how they're going to interpret this or how a court might interpret this, but it's definitely something that would give me pause if I was a USCCA member.
It's a really strange language, and it seems to imply that they can terminate you if they determine that your conduct is criminal or that your intent during the incident was criminal. To be fair, I think I understand what they're trying to say with this language, which is if you make a fraudulent misrepresentation or something like that to us while you're telling us about your incident or something like that, then that's grounds for termination. But, I mean, they get to decide what's a criminal or fraudulent representation. Maybe a member is just mistakenly reporting something to them in good faith, and if they determine, okay, there's a misrepresentation. But you're right, Mark, the language is squishy enough that it seems to say, oh, by the way, if we determine that your intent was criminal at any time during the incident, then we have the right to retroactively terminate you. But don't worry, we're not going to give you a lawyer. We'll give you your money back. Here's your money back that you paid for us, but you're not getting the benefits that you paid for.
Yeah, so that would be something that would be on my mind if I was thinking about joining USCCA. But then there's this other section, amendments or changes to the membership agreement. Here's what this says. USCCA reserves the right to change the membership agreement terms at any time without notice to primary member or secondary member. USCCA shall post the most recent version of the membership agreement terms on its website, and the membership agreement terms on USCCA's website shall constitute the current, binding, and enforceable membership agreement. Primary member and secondary member agree to be bound by the terms of the then existing membership agreement posted on USCCA's website. So I don't know how they're going to apply this, but it's pretty clear from the language here. They get to change the deal. They don't have to give the members notice. All they got to do is post it on the website, and whatever the new deal says, that's the deal that you're all held to.
Yes. So still no coverage for residents of New Jersey, New York, or Washington. That's been the same, I think, for a while, and that is still the case.
Yep.
All right. So now, Mark, time to get to some of these changes that we're not too excited about here. So in that email, you can click a link, and the link sends you to this chart, and the chart purports to show the differences between their previous policy and their new policy. And so if you take a look at this section called coverage determination, this one gave us some pause. So the previous policy, it says coverage determination. Coverage was determined by impartial individuals employed by the insurance company. Current policy, coverage determination. The insurance company is contractually required to provide coverage so long as you can, in good faith, assert self-defense as a justification under the law. In other words, there's coverage if your defense attorney believes there is a good faith self-defense claim, and the judge allows you and your attorney to make that argument in court until a final non-appealable finding of guilt is reached. And then it says, here's why. Previously, individuals employed by the insurance company reviewed each case to determine if it was self-defense or not. To best serve our members, self-defense is now determined by if you and your attorney can, in good faith, assert self-defense as a justification. And the same language is in the email.
So the problem with this language is Nowhere in the insurance policy does it say any such thing.
Yeah, let's bring everybody's remembrance back to those disclaimers at the bottom of the emails and the website and everything saying, hey, this is just for informational purposes, and we're directing you over to the insurance policy. So we go to the insurance policy and we don't see any language like this.
I've read the thing cover to cover, and maybe I'll be corrected here, but I didn't see anything that reflected anything remotely close to that language, and I saw language directly to the contrary. So let me direct people's attention to Section 1, Part A, Subsection 1A. And here's what it says. Quote, we may, at our discretion, investigate any occurrence, and we may settle any claim seeking compensatory damages that may result. And it continues on about limitations. Also, Section 1, Part A, 1E has essentially the same language.
That's right. It says, we may, at our discretion, investigate any occurrence, and we may settle any claim for compensatory damages that may result.
Okay, so you may wonder, who's we?
Who's we?
Is we, you, and your lawyer?
Or
no.
the lawyer and the judge, or, anybody else?
Well, fortunately, we is defined in the third sentence of the actual policy. Here's what it says. Quote, the words we, us, and our refer to the company providing this insurance. Again, we is Universal Fire and Casualty Insurance Company. So this impartial coverage determination not only is the language that's cited in both the email and on the chart nowhere to be found in this contract, but the language in the contract seems to be exactly contrary to that. It's the insurance company that has the right to investigate the claim, and presumably if they're investigating for a reason. That's to deny or accept the claim.
Yeah, so what I take from this is they say in that email very proudly, hey, great news, the insurance company doesn't make the decisions unilaterally anymore. It's now up to your attorney and the judge on whether they allow a self-defense or whether they think that self-defense is arguable. But at the bottom of that email, it says, this is just for informational purposes. Make sure to refer to the contract. And then when you go to the contract, it ain't there. So I don't even know what to make of this.
Sure doesn't seem accurate to me. I mean, that's my take on it. My opinion here is this is not accurate.
Right.
So they've asserted one thing. The contract not only doesn't say that, but says something to the contrary. So we'll just leave that where it is. Again, I don't know how anybody's going to interpret this, but when I look at it, it sure doesn't seem accurate to me.
All right. Moving on to the next subject is these emergency calls. If an incident occurs for a USCCA member, they make an emergency call. And there's actually some information that they provide in an FAQ on their website that says, what should a USCCA member do in the case of an emergency?
Okay, so if you got that email and you clicked on the Learn Here and you saw the chart and you scroll down underneath that chart, what you'll find is an FAQ section.
So on that FAQ, there is a question on there. As a USCCA member, how do I obtain a USCCA network attorney after a self-defense incident? Answer from USCCA. If you've been involved in a self-defense incident, your first call after 911 should be to the Critical Response Team. You will be connected with one of our Critical Response Team case managers who are available 24/7, 365. Your Critical Response Team case manager will help guide you through the aftermath of a self-defense incident, helping you retain a criminal defense attorney of your choice or from an experienced attorney from the USCCA Attorney Network.
Where do we begin with this problem? This is clearly not an attorney you're talking to, right? So if you get in an emergency situation, you're going to call and speak to a Critical Response Team case manager, not an attorney, and that person is going to guide you through the self-defense incident. That's the person you're going to talk to and tell them what happened. This is all discoverable. And we found this out in the Colie case, remember? That was a case, for people who don't know, maybe we should put a link at the bottom of this video to the Colie incident. He was a USCCA member. He called. He spoke to the Critical Response Team case manager. And the prosecutor found out about it and tried to get a subpoena to get all of that conversation, records, information. They could do a deposition. Fortunately for Mr. Colie in that case, the prosecutor found out about it too late and filed to get that subpoena too late, and the judge denied it. But anything you say to somebody who's not part of a law firm, not a lawyer, this is all discoverable. And this really gets to the heart of why dealing with a law firm is better than dealing with an insurance company.
Yeah, that attorney-client privilege in that moment after your self-defense incident is so important. If it's literally anybody else other than an attorney, then every single thing that you say can and will be used against you if it's discovered by the prosecutor. And that moment after a self-defense incident, there's a lot going through your head. It's oftentimes very traumatic. Oftentimes you say things that you don't mean, or you say things in the wrong way, or you explain things differently than ultimately is supported by the evidence. All of that comes in against you if the prosecutor seeks it out.
Yeah, to be fair, this is a giant problem. I mean, that's the only thing you're going to want to talk about at that moment in time. Hey, I've just been involved in an incident. Ding, now you've admitted you're the shooter, right? They're going to say, what happened? I mean, what are they going to say? Oh, great, let me connect you with somebody. They're going to talk about what happened. That's what you're going to want to talk about. Did you know the prosecutor could call that person, that critical response team case manager, set a deposition, sit them down, put them under oath, and say, tell me everything that the defendant told you in that very first call. And not only that, anything that person communicates to the attorney is also not attorney-client privilege. This is a giant problem, and this just highlights why, if you're dealing with a criminal defense matter, you really got to deal with a criminal defense law firm. So there's just no way around this. This is a major problem.
Here's another problem. One of the terms of the contract in order to get an attorney assigned by the USCCA has an interesting requirement of their members. It requires them to send a detailed report in writing to the insurance company within 10 days of the incident, of the charge. It's unclear, first of all, within 10 days of what?
Just when you thought that this couldn't get any worse, right? I mean, maybe you're thinking, okay, I'll call the critical response team member and just say, I need an attorney. And that's it. That's all you say. Okay, great. That's not going to be sufficient to trigger coverage here. And so let me direct your attention to Section 1, Part A, subsection 1B5. Here's what it says. This insurance applies only if, drop down to 5, the claim is reported to us in writing in accordance with paragraph B of Section 3, self-defense liability conditions. What does Section B of Section 3 say? It's under a section that says duties in the event of occurrence, claim, inquiry, or proceeding. 1, as a condition preceding to your rights under this policy, you must see to it that we are notified in writing of a claim or an occurrence that may result in a claim as soon as practicable, and then there's some limits there. If you get down to Section 2 here, here's what it says. To the extent possible, notice should include how, when, and where the occurrence took place, the names and addresses of any injured person and any witnesses, and the nature and location of any injury or damage or any legal proceeding arising out of the occurrence. Notice of an occurrence is not notice of a claim. And then you get down to Section 3B, makes it very clear. Here's what it says. A claim caused by or resulting from a law enforcement inquiry arising out of such occurrence that is commenced within 36 months after the end of the policy and is reported to us in writing within 10 days of the insured receiving notice of it shall be deemed to have commenced and made at the time such initial notice was received by us. Section B4, here's what it says. You and any other involved insured must A, immediately send us copies of any demands, notice, summonses, charges, or legal papers received in connection with the claim or other legal proceeding. Authorize us to obtain records and other information. Cooperate with us in the investigation, defense, or settlement of the claim or other legal proceeding.
All right, so my very first question when I read this, Mark, is this 10-day time period that you have in order to send them a detailed written statement, when does it start running? Is it from the date of the incident? Is it from the date of the charge? Those two things happen on different dates oftentimes. Is it from the date when you're taken into custody, when you have court? It's not super clear to me when the 10-day time period starts running. And that's really important because if you miss the 10-day time period, it appears that all of this contract is kaput.
Yeah, and what if you're in jail? I mean, what if the 10 days start at the time the incident occurred, which seems to make sense under the policy? You've been arrested, you're in jail, you haven't been able to post bond for whatever reason. Maybe you're held no bond based on the charge. If you don't get them a very detailed written notice, it certainly appears from what we just read, you're not going to have any coverage at all. Not to mention the fact that anything you say to not just the critical response person who answers the phone, but to the insurance company in writing, who, what, where, when, why kinds of questions, all of that is discoverable. You can just throw your attorney-client privilege completely out the window here.
Yeah, and my first thought was to kind of put those concerns in conjunction with one another. Say you're in custody, which is very common after a shooting incident, and in order to try to comply with this 10-day deadline to get your written statement, you write your who, what, when, where, why. You send it. You attempt to send it from the jail to the USCCA. Just so everybody knows, the jail opens and searches and reads and forwards oftentimes to the prosecutor every single piece of mail that somebody sends in or out of a jail.
Other than attorney-client privilege, which always has to be marked on the outside, attorney-client privilege. And by the way, they look at that and because, they're savvy enough to realize anybody can write attorney-client privilege. It's got to be addressed to the law firm, right? So this is just unbelievable to me, right? Not only does this fly in the face of attorney-client privilege, but you just can't do this.
Yeah,
right?
and this is definitely before you've talked to a lawyer, because the lawyer coverage is not triggered until you send this statement in. And so one thing's for sure, when you are writing down your required statement in that 10-day deadline in order to trigger your coverage, you have not consulted with a legal professional on the who, what, when, where, why, what the applicable statutes are. You might say something stupid in there. You might say something that forecloses a future defense that the evidence ultimately supports. This is just wrong.
There are so many things wrong with this. We could spend the next hour just talking about what's wrong with this, but it should be obvious to everybody, right? If you're arrested and charged with a crime, you got to give a written notice of the who, what, where, when, why to people, and that's all discoverable, right? That the prosecutor's going to get and use against you. This is unnavigatable as far as I'm concerned.
All right, so next up is one that they've been touting for a long time, which is you have the ability to choose your own lawyer.
Yeah, let's look at the FAQ here.
Yeah. All right, so on the FAQ, the question is, do USCCA members really have the freedom to choose their attorney? Answer, yes, USCCA members can choose their own attorney. However, this attorney must have the necessary professional experience to represent the USCCA member in their case, and the attorney must agree to the insurance company's customary rates and reporting and billing guidelines. If you do not have a specific attorney you would like to use, the USCCA Attorney Network has over 1,200 available attorneys.
Yeah, so on the point of can you choose your own lawyer here, I would say not exactly. Okay, so that's great that the FAQs represent this. But as we know, and established at the very beginning, it's all about what the policy says. And if you take a look at that pesky policy again, and you look at Section 1, Part A, subsection 1D, here's what it actually says. Quote, we have the right to assign counsel of our choosing to defend the insured against any claim to which the insurance applies. We will not unreasonably withhold approval of defense counsel requested by the insured, provided that such counsel, number one, has, in our sole judgment, the necessary professional experience to defend the claim, and two, agrees to our usual and customary rates and reporting and billing guidelines, end quote.
Yeah, we've talked about this section before because one of the big selling points that I see USCCA talking about is you get to choose your favorite lawyer, the best of the best, and they've had this clause in there that seems to say, not really, because I have lots of questions about this particular clause. For example, what are their customary rates and reporting and billing guidelines? Because in order for the USCCA to approve your attorney, they've got to agree to all these things. And so my first question is, what are they?
Well, first off, they don't have to agree to any attorney, right? You can say, hey, here's who I want, and they can say, sorry, no, period. They have the sole discretion to do that, right? They get to assign the attorney they choose. But okay, they won't unreasonably withhold, so long as the lawyer agrees to the billing rates. What are the billing rates? Because the lawyer you want is going to want to know. That's going to be question number one, right? How much is this insurance company going to pay me? And let me just say, insurance companies are notorious for paying bottom low rates. Now, we don't know, right? A question might be, what is the rate? There's nothing in the policy that says anything about what that billing rate is. Maybe it's $1,000 an hour. I doubt it. But we don't know, and there's no information here about what that billing rate is. It'd be really nice to know. I mean, if I was somebody thinking about signing up in USCCA under this statement that do I really get to choose my own lawyer? Well, yeah, sure you do. We get to really make the final decision. But whoever you choose has got to agree to the billing rates. I'd really like to know what the billing rates are. If you want a lawyer at our firm, recognize that there are different billing rates. Our rates at our firm are anywhere from $350 an hour to $850 an hour. The lawyer you might want on the case, what will those billing rates be, and how much will they pay? None of that is known here.
That's right.
So also they got to agree to the billing guidelines. How much aggravation is involved in billing guidelines for the insurance company? Who knows? I have no idea. Nobody has any idea based on this contract. But the other very important part is the reporting guidelines. Mm-hmm. What do you mean reporting guidelines? The lawyer who agrees to take this case has got to comply with reporting guidelines to the insurance company? Are you kidding me? What is it that the insurance company is going to want to know? I mean, I think we have a pretty good idea here, right? What's the claim about? What happened? Was it a legitimate act of self-defense? And as information becomes known on the case, and maybe this is what happened in the Kayla Giles case, right? And for people who are interested in that one, really, you could just Google Kayla Giles, Giles, it'll come right up. But this is a situation where USCCA did pay $50,000 for the defense, and then later on, more information was received and they changed their mind. So if a lawyer is really working on behalf of their client, which I imagine most lawyers would be, and they uncover information that says, oops, maybe this thing isn't a legitimate act of self-defense or there's some other problem here. I happen to know if I tell the insurance company this, there's a chance they may deny this claim. I'm not going to agree to any reporting guidelines.
Yeah, we've talked about this extensively, the conflicted position that this puts a lawyer in who comes across information in the case that they think might cause the insurance company to drop their client. And so understandably, you might be very apprehensive to give that information over. Also, there's questions about whether or not this resolves any ethics issues whatsoever. They try to claim, the USCCA has tried to claim that, there's a tripartite relationship, and so there's confidential things. Okay, well, that has to do with confidentiality. It doesn't have to do with the issue of whether a conflict can arise because of the information you're presenting.
There's so many problems here. This is another one we could talk about forever. I mean, I can't imagine a client coming to me and saying, insurance company is going to pay, okay, what are the rates? Even if I agree to those rates, hey, they want me to report to them about things on the case. I got to answer questions. I mean, even if I agreed to that, the client would have to sign a waiver of attorney-client privilege. Now, once that's signed, everything that's reported is entirely discoverable. Again, I don't know how any competent criminal defense lawyer who's actually dealing with a serious case is going to agree to report, and we don't even know what the guidelines are because they don't tell us here, is going to report information about that case to the insurance company. And, just as a side note, even the argument that is made here, which of course there's no evidence of in the contract, that you get to decide with your lawyer about whether or not coverage applies. The lawyer that they're paying you, that lawyer, the one
in their sole discretion.
Yeah, the lawyer that the insurance company gives you in their sole discretion, that's the lawyer that's going to decide whether coverage applies here. There's all kinds of problems with this.
Yeah, that's a conflicted position to be as well, because you're highly incentivized at that point is, oh yeah, this is definitely self-defense. I'll say whatever I need to do basically in order to keep the money coming. So there's some interesting conflicts that this creates ethically for the lawyer in that situation.
Yeah, so as to the claim, do I really get to choose my lawyer with USCCA? I'd say, not exactly.
All right, so this is a topic that we spend a lot of time talking about when we do these types of policy reviews, because it's an important question to people. Under what circumstances will I be excluded from coverage? I mean, that's the worst possible thing that can happen, is that you sign up for one of these policies and then you attempt to act in self-defense and you try to make a claim and you're hoping that that company will have your back. And then it turns out that you fit the criteria for one of their list of exclusions that allows them to completely disclaim any coverage.
Yeah, I mean, USCCA goes to great pains here to make the case that they've eliminated so many of the exclusions. But let's talk about what the policy actually says. If you look at Section 1, Part A, Subsection 2, it's entitled Exclusions. There's a whole bunch of things on there, and it starts out with the following language. This policy does not apply to and provides no insurance for any claim arising out of, and then there's your laundry list.
All right, so you're taking a look at the exclusions section, and there's the laundry list. It lists a few there: expected or intended injury, criminal acts, which we'll talk about in a second, contractual liability, non-insured employer's liability, professional services, war, occupational use, damage to property, electronic data, mysterious disappearance. Okay, but they're tucked at the bottom. The very last one on the list is a little bit of legalese there. It's a statute, violation of 18 U.S.C. Section 922. What on earth does that mean?
Yeah, to the person who's maybe a lay person, right, who's looking at this contract, they happen to see some statute at the end. Maybe this isn't a big deal. But for the more informed person, the more astute observer of what's going on here, and again, don't take my word for it, just Google 18 U.S.C. 922. And guess what's going to come up?
I have a copy of the statute here, Mark, and as you can see, about size 6 font, and it's 14 pages full of conduct that could get you in trouble under 18 U.S.C. 922. And criminal defense attorneys that practice in the federal system are very familiar with this statute. I've heard this statute referred to as the ATF's best friend. It includes all kinds of conduct that is criminalized by the federal criminal code that can get you excluded under this inconspicuous last exclusion here on the list.
Yeah, but just simply citing this statute, right, which looks pretty unassuming all by itself. So 18 U.S.C. 922 includes a gigantic number of exclusions, right? Illegal weapons. There's a problem with your weapon. There could be countless reasons there's a problem with your weapon. A serial number problem, length of barrel problem, FRT triggers still not resolved, bump stocks, all kinds of new innovations. If there's any problem with your weapon, sorry, that's going to be in violation of 922. If you're a prohibited possessor, and you may not even know you're a prohibited possessor. Say you had a domestic violence 20 years ago. You threw the tuna casserole at somebody and you took some deal in some misdemeanor court, paid a little fine, did some counseling. You might not even know you're a prohibited possessor. Sorry, you're in violation of 922. If you're an illegal drug user, lots of people are smoking marijuana, other drugs involved. There's a temporary restraining order. One of those red flags are in play. You're in violation of 922. Have you had a mental health issue? If you got a firearm, you're in violation of 922. Did the thing happen in a school zone? You're in violation of 922. Minors is interesting.
It is an interesting one because I noticed on one of their updates to the policy, they said, hey, good news. Now we're automatically counting any family members that live with you under the same roof, including minors, now are included under the umbrella of your policy at no additional cost to you.
If the incident happens in the home.
If the incident occurs within the home, that's correct. And so the idea of a minor possessing a firearm and acting in self-defense seems to be in direct contrast to this section in 922. Yet another exclusion is firearms in the hands of minors.
Yeah, there's a lot of exclusions. I mean, first of all, there was a laundry list before we even got to Section L. But just by putting in 922, and people should take a look at this statute for themselves. It's the main statute that you get charged with federal gun crimes.
Right.
If you're in violation of anything in that statute, sorry, this policy isn't going to apply to you.
Yeah.
There's also other things that I'm left hanging with questions, right? What if you're using alcohol? What if the incident arises out of domestic violence? What if it's imperfect self-defense? You tried your best, but you blew it. What if you had a negligent discharge? All of those are sort of questions in my head. I don't know, and I can't tell from reading this insurance contract whether or not any of that is also excluded.
There's another interesting wrinkle to it here that is clear from how they define things in their contract. Definitely, it appears that acting in defense of property would be an automatic exclusion. So rather than acting in defense of a person, acting in defense of property seems seems to be very clearly excluded by the language of the contract. So Section 5, definitions, subsection A says an act of self-defense means the use of objectively reasonable force by the insured to protect persons. So leaves it absolutely clear you're only going to be covered if you protected yourself or another person, not property, which I think is interesting because there are many use of force incidents that involve the defense of property that won't be covered here.
Yeah, and I think also there's something else that might be snuck in here as well. An act of self-defense means the use of objectively reasonable force, right? So what if you subjectively tried to act in your own mind? You thought you were acting in self-defense, but it turns out you blew it. Well, then it's not objectively reasonable and therefore not an act of self-defense, which is why I raised the question of imperfect self-defense, because it certainly seems that if you blew it, there's at least an argument here that it doesn't constitute an act of self-defense, and you may not have coverage here. So this is sort of tricky, the way they've defined an act of self-defense. It's got to be objectively reasonable, and it's only used in protecting a person. So if you get involved in something, as you say, to protect property, right, which might even be your home or your wallet or something like that, it seems that whatever happens there, it's not an act of self-defense, and it seems you may not have any coverage there.
Yeah. Returning to Tim Schmidt's email for another point, it specifically says that gun-free zones, post offices, government buildings are not excluded. We won't disclaim liability for coverage in those areas. But once again, that disclaimer at the bottom points you back to the insurance policy, and we read it from cover to cover, Mark, and I couldn't find any such language saying that they guarantee to represent you if you're in one of those places.
No, there's no language in there about we'll agree to represent you if the incident happens in a gun-free zone or a post office or a government building. So, well, they may say that in each of these cases, right? Whether it's the email, whether it's the website, whether it's the membership agreement, it says, hey, look, anything we're saying here basically goes back to the contract. This is just for informational purposes. You really shouldn't rely on it. Go to the contract. And when you look at the contract, it certainly doesn't mirror what is in those documents that were sent to people.
Yeah, why not include it in the contract? That's what I want to know.
Continuing under the same sections of exclusion, which is Part 1, A2, subsection B, there's our old friend again, right?
Hey, there it is. I recognize this one.
Criminal acts. Why still include the criminal acts language? If you're trying to say, look, we're taking it out of there, but then you still include it in there, it really raises questions. And then, the criminal acts, the way it's written, let me read it. It says, any actual or alleged criminal act by any insured. That's excluded, including any injury or damage caused by or occurring during any criminal act of insured for which self-defense is inapplicable as a justification or unavailable as an absolute defense under applicable law. I got to say, that's confusing to me because I don't know the for which self-defense is inapplicable language, if that applies just to injury or damage caused, or if it applies to the whole section about an actual or alleged criminal act. I can't tell. And, I'll also say, too, another thing that's very confusing about this policy is, we're not insurance lawyers, right? We're criminal defense lawyers. Yes, we've had training in contracts, and we spent the time to read the contracts. But I actually hired an insurance lawyer to look at this contract. And he came back to me and said, Mark, it's not clear to me this thing covers anything criminal. All the language is written in civil terms. Talks about claims, talks about occurrences, talks about compensatory damages. That's all civil language. And I said, well, it talks in some areas about law enforcement inquiries. He says, yeah, maybe, but it's really not clear to me. It's not written in a way that makes it clear that criminal acts are covered. That was his opinion. And I got to say, it is pretty confusing. So it's really not clear to me exactly what's included here and what's excluded here. But if you're trying to say we don't exclude criminal acts, why include a criminal acts exclusion?
Yeah, it's right there under exclusions, criminal acts. I mean, in the very least, it's not clear.
It's very confusing.
So on the FAQ of the website, there's a question that addresses this exclusion. It says, is there really a, quote, criminal act exclusion in the policy? How does that impact my self-defense incident and my coverage? Answer from the USCCA. The criminal act exclusion has no impact on your claim if you are able to argue self-defense as a defense to the charges brought against you. For example, there's no coverage if a member claims self-defense when they were in the middle of committing a criminal act, like armed robbery. Much like most other insurance policies, the self-defense liability insurance policy issued to the USCCA does have a criminal act exclusion. However, as stated directly in the policy, the criminal acts exclusion does not include any action for which self-defense is a justification. I'm not sure it says that. It's not clear to me that it says that, but my big issue with this language here is that that's the whole point of defending a criminal case. The state is going to be saying you were in the middle of a criminal act when you discharged the firearm, whether it's aggravated assault, whether it's homicide, something like that. And the whole argument in the criminal case is whether or not you were in the midst of a criminal act when the incident occurred.
Yeah, I mean, it says the criminal act exclusion has no impact on your claim. Then why include it? And then the other thing, it says if you're able to argue self-defense. That's not self-defense as you and I understand it. That's self-defense as it's defined in the policy. And remember, self-defense defined in the policy has to be objectively reasonable. And if it's objectively reasonable, it's not a crime. So if it's not objectively reasonable, which means you blew it, it's a bad shoot, well, then it's not self-defense, which means you're not arguing self-defense, which to me means the criminal acts exclusion still applies. So it's very confusing. There's certainly room in here for an insurance company that doesn't want to cover a claim and say, you know what, it's not objectively reasonable, and therefore it's not self-defense, therefore the criminal act exclusion applies. If you want to remove the criminal act exclusion, maybe because Mark and Andy over at AOR have been hammering on it, why don't you just remove the criminal act exclusion instead of playing games and keeping it in there, but sort of telling everybody that it has no effect on your
don't
claim.
worry about it. Look elsewhere. Don't worry that it's in there.
Pay no attention to the man.
Move along.
Yeah, right.
All right, next up on that email, it says, quote, the great firefighters and paramedics who serve the public are no longer excluded from coverage while on duty, end quote. And if you click on the more information tab there, it'll send you to the FAQs. One of the questions is, will I be covered while I'm on the job? Answer, if you are providing law enforcement, corrections, recovery, or repossession services either as a volunteer or for a fee, you will not have coverage. If you are providing paid security or safety service, you will not have coverage. However, you can have coverage if you are providing security or safety services as a volunteer. All other occupations other than those listed above do have coverage while actively on the job. This includes firefighters and EMTs.
Yeah, that's all great until you look at the contract.
Right.
So let's take a look at Section 1, Part A, Subsection 2F. So here's what it says, starting from the top where it says exclusions. This policy does not apply to and provides no insurance for any claim arising out of F, professional services, injury or damage arising out of 1, the rendering of or failure to render any professional service. That seems pretty clear. No coverage. And then if you look at Section H, entitled Occupational Use, this is also an exclusion. No coverage for occupational use. Here's what it says. Injury or damage arising out of 1, any insured's conduct in providing any kind of law enforcement, corrections, recovery, or repossession services, whether or not for compensation or a fee, including any injury or damage caused by or arising from such conduct. 2, any insured's conduct in providing security or safety services for monetary compensation or a fee, including any injury or damage caused by or arising from such conduct. Okay, so this is pretty clear, right? No, there's no on-duty coverage if you're law enforcement, security, corrections, bondsman, if you're a repo person, whether you're paid or a volunteer. So yeah, maybe the great firefighters and paramedics have coverage, but the people who need coverage, I mean, firefighters and paramedics don't generally have self-defense incidents when they're on the job. They're fighting fires and saving lives from heart attack victims. It's law enforcement, security, corrections, bondsmen, repo people. whether paid or volunteer, maybe a better way to answer that question is no. There's no on-duty coverage, at least for anybody who would need on-duty coverage.
That's what the contract seems to imply. All right, so the next subject is another one of the features that the email is suggesting that has been changed for the better for the policy. And this is a big one, Mark. This is the subject of plea deals, in which the USCCA declares that they will no longer disclaim you in the event that you take a plea deal. Now, this is a change for them for sure, and it's been something that we have definitely taken them to task for in the past. Somebody put, I was under the impression that the controversy was not, quote, being charged with a crime, end quote, but, quote, being convicted of a crime. I got the impression that if your best legal option is to accept a plea bargain, and you do, you lose all coverage and will have to pay them back. Very legitimate question. Very legitimate question.
What a great question.
Here's the response from USCCA that I have a lot to say about. It says the point of a plea deal is to resolve the case without the cost, time, and resources associated with taking a case to trial. A plea deal is for the benefit of the courts and the prosecution. It is not for the benefit of the accused. A plea bargain is an admission of guilt, which results in a conviction on the individual's record. That conviction will likely come with the loss of certain rights. Accepting a plea bargain is, in the mind of the USCCA, a paltry and insufficient outcome for an honest citizen who is protecting themselves or their loved ones according to the rights granted to them by the Constitution. The USCCA wants to ensure that members receive true justice and that their lives are made whole again, and a plea bargain is simply not the answer. The USCCA's insurer has defended thousands of members, paid millions in coverage, and has never recovered any of the legal fees paid on behalf of the members. So when I read this, Mark, my very first thought is, a lawyer did not write this. This was not written by a criminal defense attorney who knows anything about how the criminal justice system in the United States of America works.
Yeah, and of course, to be fair, Mr. Schmidt is not a lawyer, although if he would like to come on our podcast here, as we've said many times, we'd be happy to have him on and have a very rational, civilized discussion with him or anybody else.
Well, Mr. Schmidt is the CEO. Is he the one sitting here answering comments? Probably not. It's possible he got on personally and did it, but who is answering questions like this? This is so irresponsible. It's false, first of all.
Yeah, no lawyer, no criminal defense lawyer is going to come on our program and say, you know what, I wrote that statement and I will defend it.
Hell
and if
no.
I'm wrong about that, contact us and let us know you want to come on this show.
So while I'm happy that something that they were calling 5 minutes ago a paltry and insufficient outcome to a criminal case, I'm happy that they've changed their position on that. But we looked into it more, Mark, and there's some troubling language regarding this particular clause.
Yeah, I think this is really bad. I think this is just misleading people. In my opinion, this is truly misleading people. And let's get into it. So let's explain exactly what's going on here. Let's look at the contract. The only thing that matters here, Section 1, Part A, subsection 1E2. Beginning with the end of the sentence for Section E, here's what it says. Our right and duty to defend the insured against any claim seeking compensatory damages ends. And then you look at Section 2. Here's when it ends. In the event of the insured's conviction of any criminal charge for any claim caused by or resulting from a law enforcement inquiry. So that's pretty clear, right? So that says, look, if you're convicted of a criminal charge, you're out. Coverage ends. But then it continues. However, this does not include the insured's conviction of or plea to any criminal charge that is not a crime of violence. Now, to be fair with this, they've laid this out all through their chart and in their FAQs.
In the email as well, they mentioned. So in the email that they sent around, it says, new feature, plea deal coverage. If you take a plea deal for something that is not a crime of violence, your coverage doesn't end. Notice very carefully there's some quotation marks around crime of violence. That's because it's a very specific term that's going to be defined in their contract. We'll get to that in a second. Some explanation there. Too often, a prosecutor will threaten to prosecute self-defenders on murder charges or offer a plea deal for a lesser crime and lower sentence. This puts good gun owners in a tough situation. Plead guilty to something you didn't do for a lesser sentence or potentially lose a murder trial and face 10-plus years in prison. This update to the policy purchased by the USCCA gives you more freedom to choose which path is right for you.
Yeah, sort of. If you take a plea deal for something that is not a crime of violence. So this begs the question.
What is a crime of violence as defined by the USCCA's contract?
So in Section 5, subsection I, a crime of violence, in quotes, is actually defined. So here's what it says. Crime of violence means any offense that has as an element the use, attempted use, or threatened use of unlawful force against the person or property of another, or any offense that resulted in bodily injury to another person. This is the exception that swallows the rule.
Right.
And this is why I think this is so misleading, right? Because look, if you are asserting self-defense, the crime that you're charged with isn't a DUI. It isn't a theft. We know what it is because we do lots of these cases. If you're claiming I acted in self-defense, you're very likely looking at some version of a homicide. You're looking at some version of an assault. You might be looking at some version of a disorderly conduct. And you're going to be offered a plea. And now you have great freedom with the USCCA to accept that plea. And coverage continues unless it's a crime of violence. But did you just go back to what we read? Can you imagine any kind of a plea on a homicide case or an assault case that doesn't involve either the use, attempted use, or threatened use of unlawful force against another person or property? But even if you get by that, it doesn't result in a bodily injury to another person?
Yeah, can you imagine any self-defense incident where you used self-defense successfully and the other person wasn't injured in some way in their person, in their bodily injury? And then, you know, as I think about the types of pleas that we get, that we reduce things down to, I don't know what USCCA thinks lawyers are pleading these types of charges down to. For example, if you're charged with a homicide, oftentimes it can be a good idea to take a plea to an aggravated assault or a lower level assault. If you're charged with
or a lower homicide as well.
Or a lower homicide. If you're charged with an aggravated assault, maybe a disorderly conduct or some misdemeanor level assault. But all of those things still count as crimes of violence as defined by this particular section of the statute. I can't even imagine a scenario. I mean, if you're charged with an aggravated assault with a deadly weapon, we're not pleading you down to jaywalking. We're not pleading you down to shoplifting. It has to be something that's a lesser included that fits factually what actually occurred. So I don't even know what they think people are pleading down to from these types of serious charges.
Yeah, I mean, look, when you do these kinds of cases, and I've been doing them for over 30 years, right? You got somebody charged with a homicide. You're definitely looking for a plea to an attempted homicide, right? If you're charged with first-degree murder and they offer you an attempt, that can sometimes be an excellent plea. But that's going to count as a crime of violence. Same thing with an assault, right? You're charged with an aggravated assault. Maybe you're going to plead that down to some kind of an attempt. Okay, that's an attempt to use unlawful physical force. Was somebody injured in either one of those cases? This is going to be hugely problematic here.
We've had many cases where our clients are charged with very serious mandatory prison felonies, and we got it reduced down to a misdemeanor assault, just a low-level bottom garden variety misdemeanor assault with probation and a slap on the wrist. Amazing plea. That's a crime of violence as defined by this subsection, and they can immediately disclaim liability.
Yeah, and on all of these crimes, there's almost always an allegation that you might call a dangerous allegation or a more serious allegation where, okay, not only are you charged with aggravated assault, but there's some kind of an allegation on top of that that might make it mandatory prison. It's almost always a great plea if they say, we'll drop that allegation. We'll drop the dangerousness, the seriousness, maybe priors. Maybe you got 2 priors. We'll drop one of the priors. We'll drop both priors. You plead to the actual crime. That could be a probation-eligible deal. but it's a crime of violence. So, as you said, it's theoretically possible, right, that you might take a plea in a homicide case or an aggravated assault case. You could come up with some kind of a hypothetical that it doesn't technically constitute a crime of violence, but I'd venture a guess to say 99% of the pleas that anybody would take who's charged with a crime, who's asserting self-defense to that crime, it's gonna fall within this definition of a crime of violence.
Yes, just so people understand the concepts here that control the lawyer's contact in plea bargaining, we can't just pick a statute for a client to plead down to out of thin air. We can't just arbitrarily pick a statute. We need one that fits the factual basis of the case. And so this is why you hear terms like lesser included. This is why you hear terms like a reduced charge. It's going to fit the factual basis, but it's going to be a lower level offense. And so it's hard to even hypothetically imagine a common plea to plead it down to from one of these serious felonies that we're talking about that are common in gun self-defense cases that wouldn't be a crime of violence.
Yeah, prosecutors generally give pleas that include crimes of violence, right, that have at least as an element the use, threatened use, or attempted use. Or if somebody's actually been injured, they want a crime that reflects that injury for no other reason so they can get restitution for that crime. So I think if you don't understand how the criminal justice system works, maybe you breeze right through this and think, oh, great, USCCA is now adding plea coverage. But if you have any kind of an understanding of how the criminal justice system works, and you're charged with a crime that you can say, I'm asserting self-defense. Actually, it's objectively reasonable to assert self-defense. I didn't blow it or something like that. And I'm going to take a plea. It's almost impossible to imagine that they're going to take a plea that's not a crime of violence. Okay, so if it is a crime of violence, one thing we know for sure with USCCA, all coverage ends.
Yeah, and another important time to note for those who aren't aware of this, about 95 to 98% of cases resolve with a plea deal. In fact, I think that we looked up the stat before this video for the federal system. 98% of cases resolve with some sort of a plea deal. In other words, a conviction that ends up on the defendant's record. And so given what we know about plea negotiations and the fact that charged crimes of violence almost always end up as a lower crime of violence if you're taking a plea, and given what we know about the fact that 98% of cases in the federal system, usually about 95 to 98% of cases on the state system, end with a plea, this is truly the exception that swallows the rule.
Yeah, to say that, hey, great news, everybody, now we cover pleas. Coverage doesn't end just because you took a plea. And then to follow it up with, unless it's a crime of violence, when anybody who's connected to this justice system knows that the chances are extraordinarily high it's going to be a crime of violence. And if it's a crime of violence, all coverage immediately ends. Now, we're just cracking the door of what's the problem here, right? Because imagine that you take one of these pleas and coverage ends. You are now left with a whole bunch of problems, right? For starters, who's going to represent me at sentencing that's coming up in 30 or 60 days?
That's right. Usually after there's a change of plea, a sentencing date is set in the future because there's a lot of important things that your lawyer needs to do to prep up for sentencing to get the best result. Well, it seems pretty clear to me here that if you take a change of plea to a crime of violence, then they can drop you immediately. All coverage ends. And now the question is, are you going to have to apply for a new lawyer or hire a new lawyer for the sentencing coming up who has to quickly get up to speed on the entire case and what the mitigation is and what to argue at sentencing? It can't be done.
And that's just a part of it, right? There's the sentencing. Then there's the appeal. Who's going to do your appeal? You thought you had this great coverage for an appellate lawyer. Gone if you took a plea to a crime of violence. What about a post-conviction relief, which is generally what's left over if you take a plea and you waive your right to appeal? Who's going to bring that if you have a claim? What about if you get sued? All this great coverage, the stuff we talked about, great liability coverage and this and that. If you get sued civilly and you're a member of USCCA and you took a plea and it was a crime of violence, which is likely, right? Definitely likely. You got nobody representing you on the civil case. You might have all this coverage for paying a judgment, but sorry, coverage ended when you took that plea to a crime of violence. Look, there's two possibilities here. Either A, the people over at USCCA were completely unaware of how the criminal justice system works, or B, they know what we know.
Yeah, absolutely.
And if they know what we know and they're putting this out there, I don't know how you get away with anything other than just saying this is just deceitful.
Mark, I've got an ethics concern here, a pretty serious ethics concern, which is the conflicted position a lawyer would be in if they know that their client will be disclaimed from coverage if they were to take a plea to a reduced charge of violence. And that is that the lawyer is going to get paid more. So this lawyer who now has agreed to USCCA's customary billing guidelines,
whatever those are,
whatever the heck that means, seems incentivized to encourage their client to pass up any plea deal whatsoever for a reduced charge of violence, even if it's a good one, right? Because they know that they're not going to be getting any more payment from USCCA. It seems like they're going to be incentivized to encourage them and push them towards a trial option because that's going to be a much bigger payday for them. And not to say that all lawyers would do that, but it's certainly a conflicted position for a lawyer to be in.
So you almost got to hire a disinterested lawyer to help you analyze the situation about the plea. But think about the situation puts the client in. If you read your policy and you're a USCCA member, you've been charged with a crime, you've run the gauntlet of exclusions and all of that, and they actually gave you a lawyer, and maybe you're charged with a homicide, really serious, and the lawyer's done a great job for you, and you get a misdemeanor plea. Just, I caused a physical injury to somebody. That's it. And you look at your policy and you say, well, if I accept this plea, it's definitely a crime of violence. It was an injury to somebody, right? Imagine a homicide without an injury or an ag assault without an... It's conceivable on the ag assault, but certainly not likely. You got to think to yourself, I really want to take this plea. I definitely want to take this plea. But if I take this plea, those guys could sue me, and I'm SOL on not only the lawyer to defend me on the civil case, but the civil judgment against me. And this, of course, gets us into yet another related problem.
The Recoupment Clause.
Oh, my word. Imagine this. They didn't remove the Recoupment Clause. We should talk about this.
So, yeah, the email contains some information about the recoupment provision, and it says, update to the policy. No elective recovery or recoupment of expenses. The previous policy purchased by the USCCA allowed the insurance company to recoup any coverage expenses if the member was found guilty. Despite the fact that the USCCA's insurer has never done this, this revision to the policy ensures that this can only happen if a government agency forces them to do so based on applicable law. They can never do it just to benefit their bottom line.
You know, I feel the same way about this that I felt about the criminal acts exclusion. If you want to get rid of it, then get rid of it.
Right.
But that's not what they did here. So
No.
if we take a look at the contract, Section 3, Part I, here's what it says. It's entitled Recovery or Recoupment. Quote, if required by applicable law, we shall have the right to seek recovery or recoupment from an insured, the amount of any payments made to, for, or on behalf of the insured, including payments made to third parties, if it is determined that coverage provided by this policy and any corresponding payments were made for matters not permitted by applicable law. Okay, so if you took a plea to let's just imagine the scenario here, right? You're charged with a crime, you assert self-defense, you've run the gauntlet of exclusions. USCCA's insurance company has said, we're going to pony up, no problem. And they paid a bunch of money for your lawyer, and they paid a bunch of money for an expert, and a bunch of money for an investigator. I don't know, let's just call it $200,000.
The bill is very, very high.
The bill is high. And you've decided a great plea has been, your lawyer did a great job. Great plea. You get that misdemeanor plea we were talking about a moment ago. You really want to take that misdemeanor deal, but you got to know in your mind, not only is coverage going to end, not only are you going to have no representation, not only are you stuck on the civil case, but these guys might be required by law to force me to pay back all the money. Now, they say they're not going to do that unless it's required by law, but they don't tell us in which states it's required.
Right.
Do you know, Andy?
No idea.
I don't know either.
And I would have liked it if they would have at least listed the states that they're concerned about that may require them to enforce this recoupment provision, but the contract seems to be silent about that.
It is silent about that. But think about the position this puts the defendant in, right? Not only upon thinking whether to take a plea, you have to consider the crime of violence exclusion. All coverage is going to end, but you might be forced to actually have to repay everything if this happens in a state where it's required by law. And they don't tell us which states this is required by. This is another, I think, real serious problem with the USCCA's insurance company here.
This one really had me scratching my head. So interestingly, on Section 1, Part A, 1E, it seems to say that the insurance company has the absolute right to settle any civil claim kind of unilaterally. Reading from that section, it says, we may, at our discretion, investigate any occurrence, and we may settle any claim for compensatory damages that may result. Yeah, that's really interesting. By signing this, you are signing over the right to settle the civil claim, it appears, to this company. And this is really interesting because in civil matters, it's always the within the purview of the client, of the either plaintiff or defendant, on whether they want to accept some sort of a settlement agreement or some sort of settlement to the civil claim. There's a famous movie, in fact, that I remember was referenced in law school with Paul Newman, The Verdict. And in that movie, people might remember that one. In that movie, he rejected a civil settlement without explaining what the civil settlement was to his client, and kind of unilaterally, as the lawyer, decided he would be the decision maker without talking to the actual client, the person, a party to the legal matter. And this was taught to us in law school in ethics class as a massive ethics violation for somebody other than the parties to make these decisions unilaterally. And you appear to be signing over your right to make such decisions in this section.
It's a huge problem, right? Because you're charged with a crime, you're asserting self-defense. Lots of times, the victim or victim's families brought a civil suit at the same time. We've faced this situation at our law firm on many occasions. You can't make any statements here, because any statement you make and say, yes, I'm liable, I admit that, we'll pay, is going to be used against you in the criminal case. You got nothing to say here. The insurance company is going to, at their discretion, decide whether to settle the claim. What if they, on your behalf, put something in that settlement agreement that is very important and detrimental to your criminal case? It appears you have absolutely nothing to say about that. Why might they do that? Imagine you get sued for $1 million, and the insurance company's thinking, oh man, we don't want to be on the hook for $1 million. But there's an offer to settle from the plaintiff that says, look, we'll settle for $25,000. Insurance company's happy about that. Get rid of this $1 million liability for $25,000. All you got to do is just admit that your insured is responsible for what happened here. They're the person who did it. Maybe that's the defense. It wasn't me. I wasn't the shooter. Maybe that's the defense. You might be admitting that, yes, we will settle the claim, we'll pay $25,000, we'll make an admission that our insured is the one that caused the harm here. They're going to take that and run with it right over to the criminal case.
Yeah, if you think the prosecutors are not going to be going after every scrap of paper that could possibly implicate you in your criminal case, if you think they're not going to go and check out that civil case file very, very carefully and use everything that they can over there, then you are mistaken. They definitely will.
Yeah, this is why, when we're, just as an aside, when we're in this position at our law firm, we always move to stay that civil case, because you can't do a deposition, you can't settle that case, you can't make any admissions, because anything you do is going to be used against you on the criminal side. But you're contracting that away here with the USCCA's insurance company. They get to settle it at their discretion. I think this is pretty outrageous, frankly.
All right, more squishy language from the contract, Mark, that really just left me scratching my head. We've got in Section 3, Part J, entitled, When We Do Not Renew. So I'm just going to read that section. It says, if we decide not to renew this policy, we will mail or deliver to the named insureds shown in the declarations written notice of the non-renewal not less than 180 days before the expiration date. If notice is mailed, proof of mailing will be sufficient proof of notice. So we both looked at this, and we both had, I think, pretty different interpretations of what this meant. Both of our interpretations, I think, were reasonable, at least defensible. But it's not clear to me what this means. The way that you interpreted this is it looks like they could just kind of unilaterally decide not to renew the policy. And the way that I read it was, well, if we do decide not to renew the policy, the reason why is unclear from this section. Here's what's going to happen. We're going to mail you notice. So it's not clear to me what this means.
I think both of those understandings are correct. I mean, I think that, first of all, it's entitled When We Do Not Renew. I think it seems pretty clear to me that they can decide not to renew the policy at any time. So if you're with the USCCA, you could just be notified with 6 months in advance. Sorry, we're just not going to renew this policy. We're done.
I mean, that would be consistent with that part that we highlighted earlier that talked about how they had the right to terminate the agreement if they felt that the agreement was not in the interests of the USCCA. So that language would seem to be consistent with unilaterally just being able to terminate any member at any time.
Yeah, I think USCCA says in their membership agreement they can terminate you. They can terminate you retroactively if they decide. This is the insurance company saying we can also decide to not renew this policy. So, I mean, I think it's interesting what to make of that, and we'll leave it to people to decide for themselves.
All right, so all of these changes went into effect on June 5th, 2024, and the USCCA said, all right, it applies to all of the members. You guys don't have to do anything. These are just perks and great new features that we're giving you guys. And, you know, my first thought, Mark, was how USCCA has dealt with some of their cases in the past and some of their former clients in the past. And I just couldn't help but think about Kayla Giles, a very, very popular story of what happened to her. You need only search her on the internet. You'll find exactly what happened. But she was a USCCA member. She was involved in a shooting. She claimed self-defense. USCCA originally gave her a lawyer whom they paid $50,000 for. The lawyer started representing her. Eventually, the insurance company decided over the lawyer's objection that this was not a self-defense case. This was just murder. And so they dropped coverage of her. They didn't pay for her lawyer anymore. He had to withdraw from the case. She got a different lawyer and ultimately got convicted. And you and I spoke to the lawyer. We had questions when we heard this story. And what we like to do as lawyers is get on the phone with people and talk to them and get their version of events. So you and I spoke to this lawyer, and this lawyer was no slouch, to say the least. This was a very experienced, seasoned criminal defense attorney. It's one of those things that when you're in this profession and you talk to a lawyer for a few minutes, you can tell pretty quickly, is this person the real deal? This guy, it's the real deal. And was telling us of his experience with how many self-defense cases he's done over the years, and he described Mrs. Giles' case as one of the most defensible self-defense cases he had seen in a long time. And he was excited about the case, and when USCCA canceled the coverage and refused to pay him anymore, he was upset, and he was objecting to it, basically. It was his objection.
He had additional evidence that had just come to light, which essentially was her daughter's statement over and over again made on the day of the incident, essentially describing the victim of the shooting as lunging or jumping at Kayla Giles at the time. And he wanted to say, hey, USCCA or the insurance company, take a look at this evidence before you make a final decision. He was dumbfounded that they didn't even want to look at that.
Yeah, and so in addition to her lawyer saying very clearly, this is a great self-defense case, the judge in that case allowed a self-defense instruction. In other words, the defense met its burden to show at least enough evidence to be able to argue self-defense to the jury. So we have the defense attorney now saying it's a very defensible, great self-defense case.
The defendant asserting self-defense.
We have the defendant asserting self-defense after a shooting incident, and we have the judge saying, all right, I've seen enough. I will allow it. You may argue self-defense to the jury. So the first thing I thought, Mark, is that according to just the language of the email they sent around, it appears that they would have covered Kayla Giles.
Well, under the criteria as alleged by Tim Schmidt in his email, yes. And on the website, yes. Not so sure with the language of the contract.
Fair enough.
But I think if you're going to say, hey, great new changes, you get to decide between you and your lawyer, why not be fair and go back and say, hey, Kayla, we're going to make this retroactive back to you. We're at least going to reimburse you the money that you had to pay for your own lawyer that we should have paid and allegedly would have paid under this new deal, even though it's, in my opinion, not backed up by the contract at all. I mean, there's lots of assertions out there about you and your lawyer decide. There's nothing in the contract about that. We've been all through this contract. So I think to make it retroactive only back to 6/5/24 is sort of the Kayla Giles exception. It just says, look, we don't want to fix that mess that we made back then. You really got 825,000 members. You're a very big, powerful, rich company. Why not do the right thing and take care of Kayla Giles?
Well, Mark, I don't expect them to extend the olive branch to Kayla Giles after the president and CEO, Tim Schmidt, has been talking about her on their videos. Of course, he made the claim that it became crystal clear that a member had been convicted or had committed premeditated first-degree murder, and he said that several times.
There was a time when it became very, very clear, and I mean perfectly clear, that a member had committed premeditated murder.
I know that their reps have been telling people that.
People still believe it.
Well, guess who disagrees with that? The prosecutor in the case. In fact, she was charged with premeditated first-degree murder, but then they dismissed that charge and recharged again as second degree, and the reason is no likelihood of conviction. The prosecutor wrote it when they dismissed voluntarily the first-degree murder case. They said, all right, we have to admit the state does not have a likely chance of convicting on premeditated first-degree murder.
Yeah, he was totally wrong about that. And they were wrong here. They shouldn't have even raked her over the coals the way they did. It's just disgusting that they came out and put videos online trashing her, putting false information out about her. They should have corrected the record. They should fix it now. It really would, if they asked me, and I said, look, if you guys have had a bit of a trust problem with the public, right, frankly, that's a fair statement. That's the problem that USCCA has had, a trust problem. This could have gone a long way to them fixing it, right? They could have just owned it and said, you know what, we made a mistake back then, or at least say, hey, under our new policy, which we're going to make retroactive all the way back, we're going to fix that problem. She would have been covered under this, even though, again, I don't see really much of a difference here.
Yeah, I mean, that's fair.
I don't see much.
That's just based on what the email says.
Yes,
right?
Based on what the email says. There's really not much going on here with the contract, other than some
the email that's there just for informational purposes and directs you to the contract where there is no such mention of that.
They could have done the right thing with Kayla Giles here, and this would have been a great opportunity for them to own it and maybe start rebuilding a little bit of trust. We recognize trust is critical. Absolutely, it's critical in every relationship you have with every other human being. I mean, look, I tell people all the time, and I pretend like I know something about them. I say, I know some things about your relationships. And they look at me like, what's going on with this guy? And I say, here's what I know. If you've got a high level of trust, you got a great relationship. If you got a low level of trust, you got a bad relationship. Well, this doesn't just apply to personal relationships. This applies to business relationships as well. This applies to all of our clients. This applies to prospective clients. If people perceive your company as not trustworthy, they're not going to want to do business with you.
So then there's also kind of a strange clause in there. It seems to limit the insured's ability to sue the insurance company, which always gives me a little bit of pause.
Why would you even do anything like this?
Right.
But let's look at it. Let's talk about it. It's in the contract. This is Section 3. Part C. Here's what it says. Legal action against us. Quote, no person or organization has a right under this policy, 1, to join us as a party or otherwise bring us into a suit seeking damages from an insured, or 2, to sue us on this policy unless all of its terms have been fully complied with. End quote. Huh? If all of its terms have been fully complied with, why would you be suing them on the contract? I mean, it seems like you're alleging that the terms have not been fully complied with. That's why we're suing you. Why would you even put something in here like this?
I also have another gripe, Mark, because while I am happy with some of these changes that the USCCA has made, and while I think that some of these things that are kind of, in my opinion, disguised as changes, which are actually not improvements at all, throughout all of it, it seems to me like they are trying to make their contract similar to the way that the attorneys on retainer contract has been from the very beginning. We have dinged them on all of these points, in fact, in the past. All of these corrections and updates that they've made, with the exception of increasing the bond and the red flag stuff, good for them on that, and credit where credit's due. But trying to cover criminal acts, trying to say that they now cover plea deals, these are exactly the problems that we've been pointing out for months and months and months. The record is crystal clear on all of this stuff. And so despite the fact that they have updated their contract and are trying to make it appear similar to the advantages of the AOR program, the thing that upset me was they never mentioned AOR. They still haven't even named attorneys on retainer or attorneys for freedom. Some of their influencers have kind of said, those attorneys selling retainers, which I thought was kind of funny. But yeah, we still haven't gotten a shout out from our friends at the USCCA.
Yeah, they never mentioned AOR at any point, and yet they put out a video saying, oh, there's all this misinformation. And well, really? First of all, we sent them a letter. People can look at our video and that we previously released. If there's misinformation, help us understand better. We sent a very detailed letter, gave them plenty of time. We got crickets back on that. Absolutely
and the same offer obviously applies to this video right here. If you think that we are misrepresenting anything in the contract, in the email, in the USCCA membership agreement, if you disagree with how we've presented it today, please let us know. And if we got something wrong, we're going to correct the record.
Yeah,
always.
You know, Andy, maybe we should send a letter and just say, look, there were some things in
Our
here.
last letter wasn't very successful, Mark.
No, it wasn't.
They didn't respond.
We're responsible for how we act.
That's right.
Right? And so we're not responsible for how they act. And I'll take responsibility for what we do at our law firm, but not what other people do. And so maybe the right thing to do here is to put down some of the things that we're unclear on and say, look, you know, we made a video and we certainly don't want any misinformation. In fact, if we got something wrong, we will correct it. We'll come out with another video and say, hey, here's what we previously said. Here's what was wrong about it. Now we're correcting the record. And send a letter. And we'll offer the same kinds of things. We're not trying to put gotcha questions out there. If you guys got questions for us about our program, happy to answer them. I've said we'll meet with them. We can talk live if you want, if you're more comfortable in a live form. You don't have to send Tim Schmidt. Send Tom Grieve or send some other lawyer. We'll sit down, have a civilized conversation. If you want to do a pre-recorded thing, okay, that's fun. We're happy to do a live thing. But if you want to do a pre-recorded thing so you can edit out things you don't like, that's fine. We'll do that as well. No problem. If you just want to send us questions in the letter, we'll answer reciprocal questions as long as it doesn't violate any of our duties of confidentiality or attorney-client privilege, no problem.
I wish there was a USCCA released video where the attorneys on retainer contract was likewise scattered all over the table while some lawyers talked about it. I would love to see what they have to say about our contract.
The thing is, anything they can say, we've already said.
That's right.
Because we did a critique of our own program with our own contract. Plus, as everybody who has signed up in AOR knows, you automatically get what I call the excruciatingly long, it's over an hour, video of me reading every single word of the AOR fee agreement, explaining stuff that's in legalese, making sure people understand. So what could they do? Because we've already put it out there. We actually want people to know everything that's in the agreement with our law firm, what it means, how it works, what it doesn't include, what it does include, what the pluses, minuses. We've already put it out there. There's nothing else to discuss. They want to do that, happy to do it. But look, I think we have done everything that we could do to be as fair and as unbiased here. Although I think it's pretty clear, I'm not very impressed with the new updates. I think there are things in here that you could call sneaky, that you could say there are exclusions disguised as coverages here. Mm-hmm. Did they think we were not going to take a look at what a crime of violence is? I mean, to sit out there and say, we now cover pleas, coverage doesn't end, everything's great, unless it's a crime of violence. And then,
which swallows, as we pointed out, 99% of pleas in these cases at least.
Yeah, and so if you take a deal, pretty well we can say very high likelihood your coverage is going to immediately end, and then you're screwed.
To be fair, there's another alternative there than they were being sneaky. They just know nothing whatsoever about the criminal justice system. As you pointed out, either they have absolutely no idea what they're talking about, or this is a little bit sneaky on their part.
Well, let's be charitable here and say it's certainly possible that the people who put this together, I mean, this contract isn't written like it's for criminal acts to begin with. It's written as a civil. Let's be charitable and say maybe they just don't understand. Because the other alternative, frankly, I don't like, is that they're trying to be deceitful. And I don't know which it is, but you can certainly read it like that. But I'm not going to make that conclusion. I'm going to leave it for people to decide for themselves. We've cited the sections of the contract here. It's available. It's available on USCCA's website. Feel free to comment on this video if you think we got something wrong, if you think we were unfair about anything. Point it out. Let us know. But I think that's about as comprehensive a job as we can possibly do. We've ticked the boxes that we care about, which is acting with high character, being completely transparent and authentic about what we're about, and being committed to excellence. I would say we were committed to excellence in reviewing this project here. I spent a lot of time reading every single word of the contract. You did as well.
But, once again, there's good here. There's good changes here. There's actively bad changes, and then there's some questionable stuff.
Yeah.
And the questionable stuff is the stuff that I want to ask some questions about in a new letter. I think it is worth it to kind of go through these things, because as we were going through today, Mark, I would put, like, if it was some language that was squishy, or we kind of disagreed about how to interpret it, or we didn't understand, I've been putting question marks as we go through everything. And so that could be the good basis for a new letter that we could make a video about and say, here's the stuff we weren't sure about, and we want to give the USCCA a chance to respond to us, maybe even take us up on a podcast or some sort of a public debate or conversation about this stuff. I'd love to.
Should be pretty clear we're not shy about that. But let's do what we did last time. Look, if you guys have questions that you think we should ask the USCCA, put them down in the comments. We did this last time when we sent
and
a
we
letter.
Came up with a great list.
Yeah, we did. So put down, if you have questions that you want us to send over to Tim Schmidt. Look, they can't be gotcha questions. They got to be classy. I don't want them to be calculated to be unfair, or, when did you stop beating your wife kind of questions. They need to be fair questions. Put them in that format. And if it's something we're not planning to ask, we think it's a good question, we'll include it in the letter, and let's see what we get back. We'll act with high character. If they don't want to answer again, then that's on them.
Yeah, absolutely.
And on that point, Andy, I think it's really important for people to do their homework, right? Because if you sign up in AOR, what you're really saying is, I want the lawyers at the Attorneys for Freedom. Yes, you get to pick your local attorney. That's fine. If you don't know anyone, we'll do our due diligence and get you the very best person who we can find in your local community on the team. And that happens very quickly, by the way. We have other videos out there about our strike force. We've never missed having a local attorney there at the very first opportunity for a hearing. We've had meetings at the jail with clients. So after that initial appearance, we get admitted via the Pro Hoc Vice rules, and we actually get on a plane and go to where that case is happening. We go to the state, whatever state it is, anywhere in the continental United States or Alaska or Hawaii. That's right. You will get me or Andy or one of the lawyers on our team, or maybe more than one of the lawyers on our team, along with the local attorney you've chosen, or a local attorney that we've chosen, that we've vetted ourselves. We want to put the best possible team together. But learn about our law firm. Find out what we're about. If you're going to sign up in AOR, learn about what this firm is about. This firm isn't brand new. The Attorneys for Freedom law firm has been around for 27 years. We actually are for freedom. Our attorneys are activists. We started a global peace movement called the Live and Let Live Global Peace Movement. If you're a freedom person, I know most of the people here are pro-guns, and great. I'm pro-freedom. Now, that makes me pro-guns as well, but it makes me pro lots of other things. It makes me pro-live and let live. Find out about what our team is about. Find out about Live and Let Live. That's really easy. Just go to the website, liveandletlive.org. Check out the movement. If you like what we're about, we're trying to do something to improve the world. Will we be successful? I don't know. But we're going to make our best efforts to put a real, hardcore, pro-freedom, pro-peace, and I'll say pro-gun position out there for all competent, responsible adults.
All right, everybody. Well, on the subject of educating yourselves and getting as much information as you can about different products on the marketplace, go and check out attorneysonretainer.us. Learn all about our program and what it can do for you. There you will find our contract, which is posted very publicly for one and all to see, and you can get lots of resources all about our program. If you want to learn more about our law firm and the values that we bring when we defend people, go and check out attorneysforfreedom.com. Learn about us and what we do in the legal system and how we represent our clients. And if you enjoyed this video, be sure to leave a like on the video, leave us a comment down below, and of course, subscribe to the channel and share it with a friend if it was helpful. Until next time, my friends, this has been Attorney Andy Marcantel and Attorney Mark J. Victor signing out. Peace.